Hi, I'm John Hayes. I'm a certified bankruptcy specialist in Southern California. I'm a partner at the firm of Resnick Hayes Marati. We have 7 lawyers. Most of our practice is bankruptcy. I teach bankruptcy and business organizations class actually at the University of West Los Angeles School of Law. And I thought today what I'd do is answer the question, or at least talk about this question I get asked a lot. I think all bankruptcy lawyers get asked a lot can I transfer my property to my brother-in-law right before I file bankruptcy? What happens is the client's getting beat to death by credit cards or, some loan that they haven't been able to pay, and they want to file Chapter 7 and just get rid of it. They find out early in the conversation that the trustee will sell the house because there's a lot of equity, or sell the business because there's equity. And they start, trying to figure out, well, maybe it isn't my house. What if I give it to my brother-in-law? I owe my mother a lot of money. Can't I just give it to her? And the answer to those questions is no, 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 1,000 times no, don't do it. And why? That's obviously the discerning person wants to know why. How does this work? So first of all, let me tell it to you the way I tell my students actually is I write every bankruptcy class at least once in the semester. I write up onto the board in really big letters the word transfer. Then I underline it 2 or 3 times, and I put asterisks on each side, and I draw arrows, and I tell the students to write it on their paper and put a yellow marker through it, and until they're sort of giggling about it. And I say, if you utter that word, if that word transfer comes out of your mouth, you need to come to a screeching halt and think about it. There are lots of consequences to the word transfer. And of course, I have clients that I say, well, did you transfer the house to your brother-in-law? And they say, oh, no, I just put it in his name. Well, it's either still yours and you're hiding it, or you transferred it to him. If you transferred, especially real property, if you transferred real property to somebody else, that's a taxable event. Did you report the sale on your tax return? If it's your home that you don't own anymore, supposedly, are you still deducting the interest on the mortgage, for the house that you don't own anymore? You have problems with your own taxes. I'll leave it at that. But how does this work in bankruptcy, though? Well, as I've mentioned other times, bankruptcy starts with a whole lot of forms. There's about 60 pages altogether, and one of the forms says, do you own any real property? If you check the box that says no, you don't own any property or any interest in any real property, if you actually do, you're committing perjury. All right. There's also a question on one of the forms is called the Statement of Financial Affairs. And it has a question that says, have you transferred any property, in the last 2 years? If so, explain who did you transfer it to, how much, what was it? You have to disclose all of that. So if you don't disclose it, you're committing perjury, right? And what if it was more than 2 years? Well, it's very common at the meeting of creditors that the trustees ask, have you transferred any real property in the last 5 years? And you know, they swear you in before you answer these questions. And if you say no, you've committed perjury. If you owned a business, or you own a business now and you want to, you know, get rid of it, you want to sort of, you know, bring in your brother-in-law and make believe he owns it. There's a question on the statement of financial affairs that says, have you been involved in any way in any business? Have you been an owner, officer, director, affiliate of any business in the last 4 years? If so, what's the name of the business? Was it a corporation? You have to disclose all of that, or you're committing perjury. All right, so what happens in bankruptcy then? The trustee, presumably, I mean, I certainly would assume if I was you, you're trying to figure out what to do, you need to assume the trustee is going to find out. What will the trustee do about that? He doesn't sue you, at least to start, the debtor. He sues the brother-in-law, your mother. You put that house in your mother's name. He sues your mother. And he asks the court to order your mother to return the property to you, meaning to the bankruptcy estate, so that the trustee can sell the house. So what would the trustee have to show in order to win? I mean, maybe you really did sell the house to your mother. I mean, she doesn't just automatically lose. If she actually bought it, then it is her house, right? So what does the trustee have to show? What the trustee will be telling the court is that, Your Honor, the house should be returned because the debtor transferred the property one of two ways. Either with actual intent to delay, hinder, or defraud creditors. I'll come back to that in a second. Or for less than fair value. So if you transferred the property to your mother with actual intent, your intent was to delay, hinder, or defraud creditors. Almost everybody knows fraud can be difficult to prove, but to delay or hinder, you know, the efforts of creditors to collect, you know, if you're being sued, you know, you're having financial difficulties, you're getting divorced, and now you transfer your house to your mother, you know, you're going to have a hard time convincing the court, even if you transferred it, for what it's really worth. And then say your mother pays for it with a promissory note or something. Well, now you own the promissory note. The trustee can sell the promissory note. But the trustee has to show that you transferred the property with actual intent to delay, hinder, defraud creditors. If you did, the court will order your uncle, whoever it is, to give the property back. The trustee will also ask the court to deny your discharge, but which is the worst case scenario. You know, you still go through bankruptcy. The trustee sells all your non-exempt property, but at the end of the bankruptcy process, you still owe everything that you owed before the bankruptcy started. So transferring property with actual intent to delay, hinder, defraud creditors is grounds to deny your discharge. All right, the second way that you can establish a fraudulent conveyance, the trustee can establish the fraudulent conveyance, is if the transfer is for less than fair value. So what people come up with is, well, I owe my mother $300,000, so I'll transfer the house to her because there's about $300,000 worth of equity. So at first blush, that, you know, it sounds like it'll work. I mean, if you really do owe her the money, when, believe me, you're going to have checks that show that she loaned you $300,000 and you gave her the house. If you did that within 1 year of filing bankruptcy, that's a preference. the trustee can get the property back. All right. But also, if you transferred it to her in exchange for cancellation of the debt you owed her, that's a transfer with actual intent to delay, hinder, or defraud creditors. So, you know, by the way, I'm pretty sure, I don't have the code section, but it's actually a crime as well to transfer property prior to filing bankruptcy. It's a federal crime. So no, sorry. You know, there's just, if you have some debt that you can't pay, the creditors have the right to seize your property that isn't exempt. You're creating more problems than you need, believe me, by trying to, you know, maneuver and keep the property out of the clutches of your creditors or trustees. So if you like, there's a little subscribe button at the bottom of this this video. Click subscribe. I'm trying to do one of these every week or so. Click the like button. You know, YouTube likes it when people like us. And by all means, if you have any questions, put your question into the comment section. I'm only an attorney in California. I'm not going to be able to help you if you're not in the state of California. But let me know if you have any questions. Thanks a lot. Thanks for listening, and I'll be back next week.